Thank you, Ronnie. Welcome to all of you. As Ronnie said, thank you for digging out from the snow drifts this morning and somehow managing to make yourselves available today. I am indeed honored to be here, as always, in partnership, the Texas Tribune and the Center for the Perspective Series. And of course, we're especially honored to be joined today by Chief Justice of the Texas Supreme Court, Wallace Jefferson. You probably know something about the Supreme Court, only not the Supreme Court in Texas. The U.S. Supreme Court is, it is said, where all the action is, where the nominations and confirmation fights are the stuff of headlines, where the personalities are larger than life. By contrast, in Texas, not so much, or at least that's what people assume. The 9 men and women who rule the roost here in Austin at the Texas Supreme Court are a bit of a mystery, which is a shame, because once you get to know them, they're all quite interesting, and none more so than the man to my left, who has been since 2004 the leader of the pack. Raised in San Antonio, the son of an Air Force major, Chief Justice Jefferson is a graduate of Michigan State University and the University of Texas Law School. After working for law firms for 13 years, he was tapped by Governor Rick Perry for a seat on the court in 2001 and was elevated to the top spot on the court in September of 2004, succeeding Tom Phillips as the 26th Chief Justice of the state of Texas. He is currently first vice president of the Conference of Chief Justices, an association of chief justices from all 50 states and U.S. territories, and takes over as president of the conference next year. But resumes don't tell the whole story of the first African American to serve on and lead the Texas Supreme Court, who, as it happens, is descended from slaves. His great-great-great-grandfather, Shedrick Willis, was freed after the McClellan County judge, who was his master, ruled that a free black man could not be bound by contract to sell himself into slavery. And he went on to serve 2 terms on the Waco City Council after the Civil War. It's fascinating. An amazing history that sheds only a little light on the life of his descendant. We'll try to shed quite a bit more light in the next hour. Please join me in welcoming the Honorable Wallace B. Jefferson. Thank you. Sir, good to see you.
Good to see you.
Now, I have to ask this after the last time this group was together. You're not running for governor, right?
I have no plans to run for governor.
You're sure?
I'm not running for governor.
Because I'm still pissed. But just so we're clear on your electoral path and all that, you are up again in 2014. These are 6-year terms that you serve on the court.
That's right.
And you were elected last time in 8, and as you noted to me a few moments ago, a third of the court is up at any given time, a third of the 9, and you don't fall into that bucket again until 2014.
That's correct, but I was on the ballot in November 2008, and that was quite a ride. You'll remember Barack Obama was inspiring this state, and Democrats were coming out in numbers that the state hadn't seen in many years. And of course, I'm running as a Republican. So what do you do, in the age of Obama? And what I did was put on a commercial that talked about this slave connection and said, where else in America can the descendant of a slave rise to become Chief Justice? Trying to get some of the votes of the Harris County African Americans who would come out for Barack Obama. And I think that was somewhat successful, although I lost Harris County.
But you got 53% of the vote in 08
yes.
Against a Democrat and a Libertarian.
Right.
And the reality is that if you're a candidate for judge in Texas in 2008 or 2010, it is still the case that if you have an R next to your name, you're much more apt to win than not.
Candidate for a statewide judge, but in the urban counties, in Harris County, Dallas, and Bexar County, the trend is the other way. Right. The Democrats have been winning those races since 2006.
Why do you think it is that, at least at the level of Supreme Court justice, the switch from Republican preferred to Democrat preferred hasn't taken hold?
Well, because they don't know who we are. What happens is they don't vote for the person. Even though I did well in 2002 and 6 and 2008, the polls show that 86% of the people have no idea who I am. And instead of voting for me based on merit, they vote for, in the last election, McCain, and then just vote straight ticket party, all the way down. And that's the reality. It's either the party affiliation or the sound of your name or the amount of money that you can raise and spend that determines judicial elections, much more so than the quality of the candidate the ethics of the candidate or temperament.
Now I want to make some of that mystery go away here in a little bit and talk about who you are and what you do and why you do what you do. But you've raised something that I want to bring to the head of the line here, which is the question of party affiliation in politics and whether you ought to be running at all as a judge for election, and whether you ought to be fundraising and spending at all as a judge up for election. Your predecessor, Tom Phillips, as Chief Justice, has become a real advocate for the position that maybe we shouldn't be doing it the way we do it. Should we be electing judges or should we be appointing judges? Should judges be out fundraising, often from people who may have business indirectly before the court, if not directly before the court? Right. Where do you come down relative to where Chief Justice Phillips is on this question?
The answer is we should not be doing it the way we're doing it. There ought to be an appointment system followed by retention elections, so that the focus at the very initial stage of service is on merit and qualifications. But it wasn't, Tom Phillips has been tremendous at trying to change the system, but before him, John Hill was a great advocate. He was Chief Justice. Before him, Pope and Calvert tried to change. The fact is, the change isn't made because a Chief Justice says we need a different system. You've got to go to the legislature and persuade them that a new system needs to be in place.
Well, now I know it's a shock to think that the legislature would think it knows better than the experts. I know that never actually happens, but since now 5 Chief Justices have recommended that this happen, why hasn't the legislature said, well, they know better than we know, so let's go ahead and make the change?
I think there is a philosophic reason that you might want to elect your judges, and that is judges decide life and death. They through their signature on an order can transfer millions or even billions of dollars from one party to the next. You want, and we're not more intelligent than the rest of Texas citizens. We're not better. We should be accountable. And if we are acting in a way that's activist or in a way that puts our personal views ahead of the law, then the voters want to have the right to remove that judge from office. The problem is the voters don't know what we do. So there is the accountability philosophy doesn't work when you're talking about a statewide election or an election in a place like Harris County where you go on the ballot and there are 48 judges, on the ballot, and you're supposed to be able to distinguish the 332nd District Court from the 50th District Court and Smith versus Jones from, the voters have no way of knowing, and so the principle behind electing judges, that accountability factor, I think doesn't work at the statewide level or in the major urban counties.
But you talk about how important it is that there be that accountability, but I don't remember voting for Sonia Sotomayor. I don't remember voting for Antonin Scalia or Clarence Thomas. So why is it okay for U.S. Supreme Court justices to be appointed? They say, well, you voted for the president who appointed them. That's like voting for them because you voted for the person who you wanted to make that choice. Why is it not the case that I vote for the governor and therefore the governor should have that same power of appointment and I should just be comfortable with that?
Well, I think there's a good reason to adopt the federal model in the state courts, and that is, yes, you give the governor or the president that chance, maybe subject the appointment to Senate confirmation, and then let that person serve for a term. But, in the 1930s, Andrew Jackson kind of swept through Washington, D.C. and captivated this nation in terms of popularism, that these judges are not above us, and I think because of his focus on that, around the country the states changed, and many of them adopted constitutions where judges were elected. Right. But I do think it would make sense to have that federal model, but add to it the component that the voters can vote up or down on the judge after a period of time.
This is the retention election to which you referred.
Right.
Well, let's assume that we're going to have elected judges, Chief Justice. Why not make them nonpartisan? Why do we have to have R's or D's next to their names? Why is it okay to have a nonpartisan mayor of Houston or a nonpartisan mayor of Dallas or a nonpartisan mayor of Austin, but it's not okay to have a nonpartisan Chief Justice or a nonpartisan justice or a nonpartisan justice of the Court of Criminal Appeals?
My first reform, if we're not going to go as far as I would like, would be to eliminate straight ticket voting. That's number one. So if you are going to vote for me or one of my colleagues or a district court judge, you can't just vote for the top of the ticket and bring that person into office. And that way you have to actually go down and you know something about the person you want to vote for them. You can still vote for all Republicans or all Democrats. Right. That'd be the first thing that I would do. The nonpartisan option, the difficulty I see with that is if you want to say it, there's at least a rough approximation, R&D, very, very rough, and I think usually it doesn't work. But you think of the Republican strict constructionist and not willing to expand the law. Someone like Chief Justice Rehnquist would be that model. The Democrat would be seeking more social fairness and wants to push a policy a little bit more and is willing to view the Constitution as a living document. Someone like Brennan might fit that model. And if that is sort of what you're thinking, then an R is a rough approximation for this sort of more strict construction, D for the other. If you have nonpartisan, then what's the basis? I've already said that you don't know the people that are on the ballot. So if it's nonpartisan and you just have Jefferson versus Smith, how do you know?
Well, how did I know to vote for Orlando Sanchez in Houston over Bill White when neither one was running as a Democrat or Republican? You do it on the basis of qualifications. Right. You do it on the basis of the program that the person puts forward. Why are we not able to make that distinction in the case of judges? Because
everyone knows who the mayoral candidates are. They're focused on that. You know who the President of the United States is. You know who the governor is, you know who the mayor is, but you really don't know a judge.
Do you believe, as I suspect that I know the answer to this, but do you believe that politics should be kept out of the decision to elect judges?
Politics cannot be kept out of the decision.
How about partisan politics?
Those can't either. You've got these interest groups that are very intent on bringing politics in, and they want, just as they did in for the federal courts, Sotomayor, or any of the circuit courts or federal district judges, they want to have an idea of the political stance of a judge. I mean, that's just where we are now. So it's going to play a role, but my experience has been it doesn't play a role in the actual decision-making of the judge.
Just in the choice, potentially, of the judge.
Right.
So when Kathy Adams, the new chair of the Republican Party this last week, endorsed your colleague, Eva Guzman, over her Republican primary challenger, in seeming violation of what the chair of the Republican Party, or Democratic Party for that matter, has sworn off doing, you think that's okay, or would you prefer that Ms. Adams had not endorsed one candidate in the Republican primary?
Well, I won't comment on that, except to say, thus far, today's the second day of registering to vote. I've heard of a lot of people saying that they're going to or might consider running for the Supreme Court for one of the positions on the ballot, but so far there's only one person who's serving, and that's Eva Guzman.
Justice Guzman.
Yeah.
Before we get into you, Chief Justice, let's talk about the money aspect of this. So what would you like to see the system of fundraising for elected judges be? Would you like to see a revision to that system that would perhaps insulate the bench from undue influence or the perception of undue influence from contributors who might have business before the court?
Well, we've already done quite a bit in Texas that other states haven't done. We adopted in the mid-1990s a voluntary campaign act for judges, in which there are maximum contribution limits and expenditure limits in a race, and where there's no fundraising when you are not on the ballot or you're not in a campaign. And so I think that some of what occurs around the country in terms of very elaborate, wild spending would not occur, at least directly to the campaign or from the campaign. And I think that's been an innovation that Chief Justice Phillips should be very proud about. Now, in terms of what a judge can do when he or she is running, they've got to be able to spend money. I mean, as I say, it is unfortunate that the public doesn't know who's running. So you've got to find a way to get out there and purchase TV advertisements, radio, get mailings going. And unless you want a judiciary that is filled only with the wealthy, then a person who wants to be a judge is going to have to find some mechanism, some way to raise that money to get the word out.
And so there's no change to the current system as it operates that you would advocate in your position as Chief Justice?
No, not other than a fundamental change to our system. But if we're going to be compelled to run in partisan elections and be forced to find a way to get the word out, then you're going to have to be able to raise the money and get it done. And then individual candidates or judges will make their own determinations about recusal. Many of us on our court, even though we are not required to recuse because a lawyer or a party has contributed money to the campaign, very often during that campaign will recuse, will not sit in the case because of the appearance to the public that there might be this quid pro quo, which I think by and large does not exist.
Okay. Well, let's say you've alluded to the mystery of who you all are and what you do a couple different times. Let's try to solve that problem by asking you in your own words to define what your job as Chief Justice is. I know that it's different from the Chief Justice of the U.S. Supreme Court. I imagine you refereeing disputes among your colleagues, like if you go to lunch and Harriet O'Neill wants to get the check, but Dale Wainwright wants to get the check, you decide who actually pays,
That'd
right?
be Dale.
That's pretty much Dale. What do you do as Chief Justice that is different from what you would just do as a Justice of the Supreme Court?
Well, one of the primary roles of the chief is to lead the conference. We have at least once a month for a 2-day period a conference of all 9 judges. We sit around the table and we talk about the cases that have been filed in our court, and we decide whether we want further briefing on the case. We decide whether we want to grant the case, and then having granted and heard argument, we decide the outcome of the case. And so I lead that discussion. And Justice Heck sits on my right, Justice O'Neill on my left, and it goes back and forth in order of seniority. And I might say, Justice Heck, you've written this draft opinion that says X, Y, and Z. I'm for X and Y, but I'm not for Z. You need to change that. And then Justice O'Neill may say, no, that's I'm for Z, but not X and Y. And then there's a dialogue among us that really is fascinating. It's a great, exciting part of my job, is to sort of be the conductor for this very important body of work that we do.
Are there significant differences between the court? I mean, you mentioned only on the current composition of the Texas Supreme Court would Judge O'Neill be at your, quote, left. The reality is that at the U.S. Supreme Court, you've got Justice Scalia and Justice Thomas, you've got Justice Ginsburg and Justice Breyer. You have 9 Republicans on the Supreme Court of Texas. Is there really enough difference to have to mediate?
There's a huge amount of difference of opinion on our court. And let me just tell you this quick story about what I thought when I came to, I came directly from private practice to the court in 2001. And I remember the first time that I had to deal with the legislature on something. And I thought, okay, I'm a Republican, I'm going to go to the Republicans and we'll get it done because they're in control. Okay, right. Doesn't work that way, because they're Republicans, but they're urban and they're rural. They are east and west and north and south. Some of them don't like each other. Some of them have better allegiances with Democrats, and it's kind of like that on our court. We have very
but the law,
different
sir,
backgrounds.
The law is not flexible based on geography or based on urban versus rural. The law is the law. This is what the philosophy that the Republican Party chiefly has put forward for years, that the law is not a living document.
Right.
So if that's the case, what would the difference between rural and urban or east, west, and south have to do with what their view of the law is?
My point is that not all Republicans are the same, and they're not in the legislature, and they are not on our court. And so the view of how do you interpret a statute changes from judge to judge. It's different. Some say all you don't look at anything else but the words. Right. And if the word is black, then you say black. Others will say, well, no, you need to look at the context. When this was being debated, the reason they said black is because they were talking about dark and not light. And, so maybe it's not just the color, but it's kind of the whole concept. So people have different ways of dealing with words. People have different ideas about the discretion a trial court might have over a particular matter. Some judges might think the trial court has made a ruling that, and the appellate courts ought to intervene right away, even before there's a final judgment, and correct that ruling. And other judges on the court might say, no, let's wait until it's all resolved and final in court, and then we'll take it up. I mean, that's sort of the general rule. So there are class actions and how you deal with those. And I mean, there's just many differences of opinion. So the difference in background is, some of my colleagues have been trial court judges. Some have been courts of appeals judges. Some, like me, came directly from outside the bench. Some were with big firms, some with small, and they're, just the way you look at the world is different depending on those sorts of practices.
So people are clear on this. The fact that you're Chief Justice doesn't give you any more than one vote. The reality is you are no different than the other 8 colleagues on the court for purposes of resolving a dispute or a case before you, but your Chief Justice status is more procedural, right, in terms of the backstairs stuff that happens at the court.
It is that. I've tried to say because I'm chief, you must go my way, but
How'd that work out for you?
It hasn't
so
quite
good.
happened every time. But it's procedural, but it's also you have the ability just by sort of being that conductor to move the discussion on, hopefully in a way that's collegial among your colleagues. To when things begin to get tense, which they sometimes do, and around the conference table, if you're adept, you can sort of get the tension level down a little bit. Yep. And move forward with the agenda. And then the productivity. I've got to be productive myself to lead my colleagues, or at least to urge them to make sure that justice is dispensed as quickly as possible.
You satisfied with the court in that respect? Occasionally, a knock on the court, fair or unfair, is that it takes a very long time to resolve issues before it. You think you guys are doing okay on that?
I think we've handled that because in the first, between 2001 and 2005, okay, I served with a total of 19 judges on the Supreme Court of Texas. Because people were leaving. When I first came, shortly after Greg Abbott ran for office and became Attorney General, Priscilla Owens on the Fifth Circuit, Baker left, Judge Hankinson left, Mike Schneider left, Xavier Rodriguez was there, then Smith was there, and now Paul Green is there. And Tom Phillips is gone in practice, and Craig Enoch. So you think about all these different people you've been working with, and you're trying to, nevertheless, get this body of work done and get people to have consensus on opinions. But since 2005, until just recently, the court was together. And
you said the longest time that the court had ever been composed of the same 9 people in the history of the state.
Exactly. And as a result, the productivity just went up.
But now you've got, so Justice O'Neill has announced she's not going to run again. You had, and you had two, so there were another 1 or 2 vacancies.
Justice Guzman has just been appointed, and Justice Green is on the ballot.
Is on the ballot again. So, okay. Let me ask about the role of the court generally. How is the Texas Supreme Court in its mission different from the U.S. Supreme Court in its mission? It's not just a baby version of the big, right? No,
there are a couple big differences. One of the big ones is that in Texas we have 2 high courts. There's the Supreme Court of Texas and the Court of Criminal Appeals. Our court, the Supreme Court of Texas, doesn't hear any criminal matters.
So you're entirely civil?
We're entirely civil, and there's one kind of exception, that is juvenile cases are considered to be civil cases, and so we'll hear criminal type cases there. But so, unlike the U.S. Supreme Court, we hear only civil cases. The other difference is that our court is much more involved in administrative matters. And so we oversee, for example, the State Bar of Texas. We work with the court reporters. We work with we've got legislative issues, and we testify before the legislature much more often than the U.S. Supreme Court. So there's much more in terms of administrative matters. Also, we have task forces that I'm very proud of, that engage in a form of policy. So in 2001, we formed an Access to Justice Foundation whose purpose is to dispense legal services to the poor. There are a lot of people in Texas who have no access to lawyers because lawyers are too expensive. And as a result, they can't get into the courthouse door to resolve questions about domestic violence or about housing issues and that sort of thing. And so we established this commission that is designed to make sure lawyers either will volunteer or that we have these regional legal aid associations and we can get money to them through various sources, grants and et cetera. And that has been, I think we've done a great job on that. And Harriet O'Neill leads not only that, but also a permanent judicial commission on children, youth, and families.
Right.
Before, and that was established in 2007. Before we had that, there was no real overarching judicial look at how long it takes a kid to get, who's removed from his or her home through no fault of their own. How long does it take that kid to get into a permanent situation again? The answer was we don't know. Well, now we do, and now we have programs in place to make sure that these kids are taken care of and reunited with their parents where possible, but if not, then given a permanent home, an adoptive home. So those sorts of things are vastly, I think, different from what the U.S. Supreme Court does. I think those judges, by and large, now they do have other assignments, but by and large, they work on their dockets, and then they work on whatever circuit that they're assigned to sort of oversee, and that's the biggest difference.
I'm inclined to ask you about cases that are before the Supreme Court or have been before the Supreme Court, but of course there are so many and they're very detailed. I want to ask you about one, though, in particular, that was the basis of a Texas Monthly story that ran within the last couple of months, and it involved the Exxon Corporation and the O'Connors, a prominent ranching family from Texas. And the accusation was made that the Exxon Corporation had improperly sabotaged wells on the O'Connor family's land. There was a verdict, I believe, of $18.6 million against Exxon that the Supreme Court of Texas threw out in March. And recently, a decision was made, since the Texas Monthly story, I believe, for the court to reconsider its ruling back in March. Can you give us a little backstory from the court's perspective on what happened and what's happening with that case? I know it's one that's of considerable interest to people here and elsewhere.
I'll say two things about it. Number one, the case wasn't entirely thrown out, and the public should just go and read the opinion to see what I mean by that. Number two, I kind of view this as a teaching moment, because the answer to your question is, I'm not going to say. I mean, this case is pending before our court. There is dialogue going on at our court. There are going to be briefs filed in our court on the very questions that that article raised and more, maybe less. And we're going to have to go behind closed doors and make a determination. And it would be wrong to forecast my vote. You know, of course, I only have one vote, but forecast either my vote or what the court will do substantively with that case.
Of course, I'm not asking you to tell me in advance what you're going to do. I am asking you to help us understand procedurally what happened. Now, we visited a little bit about this beforehand. The fact that the court is reconsidering the case should not be automatically interpreted, correct, that the court's going to overturn itself.
That's correct.
Right. And the fact that the court's willing to reconsider the case likewise does not mean that it's going to rehear the case. There's a distinction between that, right?
Yes, not necessarily. Well, I mean, what happens is the motion for rehearing was filed, and in that case, there were a lot of amicus briefs, and so there was a lot of law being presented to the court. The court granted the motion for rehearing, and I believe on that same day set out a briefing schedule to the parties, saying, you know, here's the schedule for additional briefing on the question before us, and I don't think that briefing has been completed yet. It might be very close. Procedurally, what will happen after that briefing is done is the case will come back before the court, and then I'll do this conducting, like I was saying.
Right.
What do we think about this case? And judges will say, who knows? We got it exactly right. We need to change something. We ought to hear oral argument again, or you know, there may be some other thing that is done.
How often does the court make this decision? In other words, is there a recent instance that you can give me of the court weighing in, whether it was entirely throwing a settlement or an amount of money that was given out, or partly throwing it out, and then it comes back around and says, actually, we're going to reconsider this case? How often does that happen?
In less than 3% of the cases that we decide that we grant rehearings, probably closer to 1%.
So what happened in this case, to the degree that you can say? Why this case as opposed to the other 97%?
Because going around the room, there are votes that said we should hear this again. And the exact reasons in each of the judges' minds might be different.
Right.
Some might, I mean, it's possible that a vote to rehear means we think we got it wrong, or it might be a vote to rehear means there's been enough law presented to us that additional clarification would be good for the state, so that
right.
People in these oil and gas situation will know what to do.
You acknowledge it's rare, though, for something like this to happen.
It's rare, but it's happened a number of times since I've been on the court.
Okay. Let's talk about you. You're really interesting to me. Your history is interesting. Obviously, we talked about the long history going back to your ancestors. But I want to ask about you and the decision that you made to go into the law as opposed to another profession. What motivated you to become this guy?
Like many who go to law school, it's because you're not sure what to do with your life.
Oh, great. The entire University of Texas Law School just
right.
sighed collectively.
I was in a liberal arts program, and we were studying, I was studying philosophy and urban affairs, and the prospect of going to a graduate school for philosophy. I took some graduate courses at
I'm
Michigan
depressed
State.
for you,
But
actually,
listen,
just thinking about
yeah,
that.
but you walk in the room, and the guys had stringy hair and beards, and they didn't eat very well, and I'm thinking, this is graduate school in philosophy? This is not going to work for me. My brother was a student at the University of Texas School of Law, and he said, you should come down and take a look here, because this is a pretty fantastic place. So I started talking to my professors about law school, and I mentioned UT, and every one of them said, if you can get in there, then you might have a chance of taking a class with Charles Allen Wright. They all knew Charles Allen Wright, and I thought, okay, this makes sense. So I came down to Austin, visited my brother, and I met Charles Allen Wright that first day. And it was not in the classroom, it was on the football field. Charles Allen Wright coached this team called the Legal Eagles, and my brother was a player on the Legal Eagles. My brother played football for Rice. Somehow, Wright was able to recruit these former athletes. But so I met him then the first time, and I thought that was great. But toured the school, was accepted, and then I had Charles Allen Wright 3 times for constitutional law for federal courts and for this seminar, in which 9 students played the role of a sitting U.S. Supreme Court judge, and we evaluated the cases that were before the court that term and decided them under his leadership. And I loved that process. And the constitutional issues I thought were just tremendous, and I thought to myself, if I could be anything like Charles Allen Wright, who had argued 12 cases before the U.S. Supreme Court and was well known throughout the world for his expertise in constitutional law, that would be tremendous.
So he was a big inspiration.
He was probably the greatest factor in terms of my moving into appellate work. And then some years later, when I filed a cert petition, the very first cert petition I filed to the U.S. Supreme Court was granted, and I didn't know what to do at that point. I got this call.
Place,
yes,
huh?
you get this call from the media, CNN and the Washington Post is calling, and all these professors, and because everyone's automatically interested in the case. And the first thing I did was ask Charles Allen Wright if he would help me. And so I came back here to Austin and had a moot court before him and 2 other professors, all who had argued before the Supreme Court. So.
And this was when you were an appellate attorney in San Antonio.
That's right.
So you got out of law school and you went to private practice.
Yes.
That was your deal. So and then in 2001 you get a call, want to appoint you to the court.
Right.
So you basically go from 0 to 60 in whatever the period of time it is. Did it occur to you in those years that you might want to be a judge, either sit for election or be appointed? Because that's like a walk-off home run on your first time up. I mean, it's really remarkable to get from being a lawyer to being a chief, or being a justice, and then ultimately being chief. It
really hadn't occurred to me to do it, and here's the main reason why is the reason that so many talented men and women don't become judges, and that is they are intimidated by this political process, by the fact that you have to put yourself out there, raise money, and subject yourself to all this criticism. So there are very, very few who just elect to run, to an open seat. It happens, and obviously we have examples of that in this cycle, but I think many people are deterred. Right. But then I got the call, and And when the offer was given to me by Governor Perry, first thought that came to my mind is what other governor, will ever offer me a position on the Supreme Court of Texas.
Why do you think the governor offered you the position?
Well, I think the.
Did you have a relationship with him before?
Didn't know him before. I didn't know him or his staff actually.
Had never met him?
Had never met the governor. No. I think it was just here's an opportunity to appoint somebody who's board certified in appellate law, who's argued before the Supreme Court of Texas and U.S. Supreme Court Fifth Circuit, and who has the qualifications for office. And let me say something about this process that really startled me, because I was thinking, like many of you, it's a political process, and I hadn't been that involved in politics.
Right.
So at some point after interviewing with the governor, his appointment secretary called and said the governor would like to offer you this position, and I accepted. And then, I don't know if it was 2 or 3 days later, that same appointment secretary called kind of sheepishly and said, Mr. Jefferson, yes, you will run as a Republican, won't you? I mean, which is to say...
What were they going to do, take it back?
Yeah.
The no backsies rule is often in effect, I assume.
The point to me is that wasn't a litmus test.
But did they not know? Did they ask you, at any point in the process of you being nominated, did they ask you, are you a Republican?
Just with that telephone call.
There was no prior conversation about your partisan or party identification prior to that call?
No, but what happens is they ask your friends, and so I'm sure that they had a pretty good idea. And I had voted in the Republican primaries forever in Bexar County. So that
I have to ask you a question. You're a black Republican.
Yes.
Well, actually, that wasn't the question part. That was more of a statement. There are currently no black Republicans in Congress. There are very few black Republicans in positions of prominence nationally. There is, in fact, a sense, fair or unfair, I suspect you'll say unfair, that the Republican Party has not been particularly hospitable to black elected officials. Help us understand why you are a Republican. And does race have any bearing at all on your decision to join one party or another?
Race doesn't have a bearing. My father was a United States Air Force officer, retired as a major. And he was a Republican, and is. Although when I say Republican, he's not voted 100%, and neither have I, for Republican candidates.
Did you vote for President Obama?
I won't say who I voted for.
You understand? I have to ask.
Yeah, but I'm excited. I was excited about his candidacy because of what it meant to the nation and the progress in not only politics, but this whole idea of access to opportunity. So that's one reason. I voted in Republican primaries primarily because of the judges. I thought the judges in most instances were very good. These were Governor Clements had appointed a whole slew of governors back in the I guess early '80s that were just highly regarded in Bexar County. And then in terms of what the party is doing in Texas, you start looking, and the first African-American that I can recall in the statewide office was Louis Stearns, that Governor Clements appointed to the Court of Criminal Appeals for a statewide office. And then I started looking at, well, there's, on our court today, there's myself and Dale Wainwright, but then there are Hispanics, David Medina and Eva Guzman. And in the history of politics in the Democratic Party, I hadn't seen that sort of diversity at the top. It came with the Republican Party, and that was sort of impressive to me. So,
you believe the Republican Party nationally reflects the values of the African American community sufficiently that you feel comfortable saying that African Americans should absolutely consider becoming Republicans?
I say they should consider it because you want to have influence in not just your own little corner of the world. You ought to, if there are principles that any party, Republican or Democrat, that you think you could help further, that are good for the nation, then why not? The Republican Party doesn't. There are many policy issues that I disagree with in the Republican Party. There are many in the Democratic Party that I agree with, and if I were in the Democratic Party, I'd try to change things around. But the truth is, I don't think about politics that much. My job is, as I mentioned earlier, what does this statute mean? What direction should the common law take? We don't get political question cases very often. And so I spend, 90% of my time, doing that instead of thinking about this political world. So that's where I am. And when newspapers will say, federal or state, this decision was by a Republican judge or a Democratic judge, I think that's laziness on the part of the journalists. I think, who cares how they came to the bench? What is what they decided respectable? Is it valid? Is it legitimate compared to the rule of law?
Okay. So on this race question, since we're discussing the notion of being a black Republican, do you self-identify as an individual who happens to be African American for purposes of this conversation, or do you consider your racial identity to be more fundamental to the way that you do your job? My sense is that you have not played racial politics in elective office in the years that you've been on the court, and I just wonder if you view the whole question of race and politics differently from the way other people do.
I don't know how everyone else does, but I'll tell you this much: it plays no role in how I decide the case. But the history you mentioned is, to me, fascinating, and I want to learn more about that.
And you referred to what you said in the way that you ran for re-election last time.
Right.
Yeah.
Yes, and the day I was appointed to the Supreme Court, after the press conference, I was at a public event, a Spurs game in San Antonio. And
that's a public event.
Yes. And people had seen this in the papers. And I had these grandmothers and grandfathers taking their kids up to me and saying, look what you can be. And I think that, that's why I'm so impressed by Obama, because it opens kids' minds about the possibilities of, that race no longer has to be a barrier. There are problems in the country, and there always will be, but it doesn't have to be a barrier. And so that's what I think about when I think about race.
As some in the Democratic Party and in President Obama's camp have said that there's a problem with racism, and the opposition to some of his policies at the federal level is grounded more in racism than in the substance of those issues. Do you see any validity in that?
Well, I don't think about it I guess I do like I do a brief. I don't think about it in terms of motivation. I look at what is the policy, and is it good or is it bad? That's how I guess I'm just thinking like a lawyer. You put this package together, and motivations, who knows what people's motivations really are.
Right.
But there's a policy goal inherent in this piece of legislation. Is it good or bad? Does it need to be modified or not?
Yeah.
And I would leave the racial politics aside.
Before we open it up for questions, let me ask you one more thing. So you've had John Cornyn and Greg Abbott as two Supreme Court justices who have gone on to elective office, not on the court, but in both cases to Attorney General. Obviously, Senator Cornyn is now Senator Cornyn. Lloyd Doggett. What are you going to do next?
I'm going to go back to the office after this and
I didn't mean
work
today.
on my opinion, work on my next opinion.
Nice try, Chief. I didn't mean today. I meant, what are you going to do in 2014 or 2015, technically, when your term would be up? And in theory, if you wouldn't run again, might you run for something else on the ballot?
I would not run for any other office. I don't have an interest. I respect people who do it because it's important to have men and women that really want to improve the lives of Texans in those positions. But that's not, I don't foresee that in my
Not
future.
your bag. Also,
No.
It'd be nice to go back and make some money again, huh? Wouldn't it?
At one point, Rhonda and I have 3 sons, and the oldest is 15, and I never want to complain about salary because I knew what it was before I came to the court. But the truth is, the state and Congress, U.S. Congress, needs to think about the compensation levels for judges, because you will wind up losing judges. The people who serve as judges are not there for monetary reasons. It's usually at a pretty good sacrifice. But there comes a point in time where the question is, do you get into debt and are you not able to send your kids to college, or should you go somewhere else and resolve all those questions. So I would hope that our legislatures, both state and federal, would consider that in terms of the level of judicial compensation.
Got it. Okay, well, you've been very kind and gracious in tolerating my questions to this point. Let's now turn the audience loose. It's Oklahoma and Texas, right? That's
Right.
it? Why don't we have the system that everybody else has?
You know, way back in the late 19th century, the problem was that civil cases weren't being heard, or at least the public felt that. Lawyers felt that their cases weren't being decided efficiently enough, and so the decision was made in our Constitution to split up the jurisdictions for the criminal and civil. But we are the only state that does it exactly the way we do. Oklahoma has a Court of Criminal Appeals, and there would be more efficiency, I think, if the two were combined. But what would the cost be? It might be, the criminal cases are given priority. So those would be decided first, and then the civil cases. And as it is, we have developed kind of an expertise in the civil area, and the Court of Criminal Appeals has developed an expertise there. But I said that I was, anonymous, that people have a hard time knowing who I am. I mean, think about the Court of Criminal Appeals.
Well, except for Sharon Killer.
Right. Who can name another judge on the Court of Criminal Appeals? If you go around the state, people, first of all, they think I'm appointed for life. Most voters are not lawyers. And then they have no clue that there are two high courts. And yet they're voting anyway. So that maybe is another reason. It's hard for people on the Court of Criminal Appeals to raise money or to get the sort of attention that you get on the civil side.
But it's also hard to, but the corollary of that is it's also hard to beat them.
Yes. Well,
so once you get on the court, if you're a challenger, you got to make a case against a ghost, basically. It's really hard to argue against somebody who nobody knows anything about.
It's hard to beat any incumbent anyway, and then as long as the demographics are as they are, statewide, it'll be hard for a Democrat to win in a Republican when there's a Republican opponent. But that's how.
Other questions for the chief?
We probably don't have enough time for me to explore it in too much detail, but I'll give you this example. Brown versus Board of Education. I had a fascinating talk with Chief Justice Greenhill, Chief Justice Greenhill, shortly after I came to the bench, and he had argued a case against Thurgood Marshall, the Heman Sweat case. And he was making the point that when you look at the adoption of the 14th Amendment in the 1860s, the Congress that adopted that amendment knew that there was segregation in schools, government-funded separation between whites and blacks. So the original understanding of that document, you would think, would say segregation is constitutionally permissible. Then Brown versus Board of Education comes along and says it is inherently unequal, it is unconstitutional, overruling Plessy versus Ferguson. If it were an original understanding applied, would I be sitting here today? Probably, maybe not now, maybe not ever. And so I am very sympathetic to this idea that you don't want judges to become policymakers. You don't want them to override the Constitution. There's a democratic process for that. But I think there have been times in our nation's history that had courageous judges not come forward, then we wouldn't have made the progress we made. So it's much more complex than people say it is, in my estimation. The default ought to be strict construction, because then it lets the political process work itself out. Then the people can march on Congress and elect senators, et cetera, and develop social policy the way they want to. So that ought to be almost always how it happens. But there's that one example that makes me hesitate.
When do you know that an issue rises to that level?
Yeah,
because obviously it's all subjective. What might be the issue that rises to that level for me be different from the issue that rises. I mean, am I remembering correctly, the audience can help, that either Justice Scalia or Justice Thomas said recently that if they were around on the court at the time, they might not have voted with the majority on Brown versus Board of Ed? I mean, the reality is different people view this issue differently. How do you not make this entirely subjective?
Well, I mean, that is the issue. I think, great innovation in our jurisprudence and our country's adoption of our system is appellate decisions have to be written. You've got to write them out, and you've got to explain for the public to see. And then professors and lawyers and politicians, they can say it's activism or what have you. You know, that conversation is going to happen. If you think it's subjective, it's going to be analyzed and exposed as such, and then whole curricula will develop around whether that was a good decision or not, as happened with Brown or Roe versus Wade or the Second Amendment decision that happened just a couple terms ago. You don't know, and this is one of the reasons that you have, you have the advice and consent of the Senate. You kind of explore what a judge's philosophy is.
Let's do one more, Ronnie. Is that okay?
Well, the question is, when does a court decide to change the law or leave it to the legislature? Very often, if it's a matter of statute, and a lot of water rights are creatures of statute, whatever we decide, the legislature can come back and amend the law to meet whatever its then preference is on the distribution of this very important natural resource. So that's one thing. There's another whole area of common law that the legislature has not codified in a statute, and then the question is, has there been a development in the law so much, or in circumstances of the case that stare decisis, the principles of stare decisis can be excused in this case, and we'll reverse an old decision. And that happens occasionally. There's a lot of debate among the court about whether we should do that or not, because there will be some judges who will say, I wouldn't have voted that way 10 years ago, but it's been the law that this many years, and we shouldn't, just because there's a different composition of our court, reverse everything that was done before. And others say, no, there's this idea of, if they got it wrong, I mean, it's just, and we can correct it, and we're here, and we could do it now, then we should. And so there's just kind of a debate about that.
Well, Chief Justice, thank you. You've been very patient and kind in sitting here with us and answering questions from me and from the audience. Thank you so much for being here. Good luck on the court. Do the people's business.
It's been a pleasure.
And maybe at some point you won't have to run
again,
and you can return to private life, and we'll see you back around here then.
All right.
Good. Thank you, Chief.
Thanks.
Good seeing you. All right.